Hi, I'm Jerry Dahl. I'm happy to be here today to present this webinar on chairing and participating in public meetings. We're going to cover a number of topics today, and let's look at the agenda. We're going to deal with open meeting requirements, the importance of a strong chair, one of my favorites, conducting public hearings, quasi-judicial actions and how that affects how we conduct a meeting, conflicts of interest and how you should deal with those while you're in the meeting and ideally before the meeting, ex parte communications, and there's one cautionary tale arising out of the state of Kansas that I think you'll enjoy. All right, open meeting requirements. First, let's talk about the definitions of local public body and public meeting. This comes from the state statute governing open meetings in Colorado. To begin with, well, who's subject to the open meeting requirements in Colorado? All local public bodies are subject to those requirements. That's not only the elected officials, but it includes the appointed bodies such as planning commissions, boards of adjustment, other planning boards and other advisory boards that are set up to advise the local governments. Really anyone that has a decision-making function, and that can include an advisory function, whereas, for example, a planning commission, you're recommending that the Board of Commissioners or that the elected city council take an action one way or another on a zoning matter. That's still a local public body that's subject to Colorado's open meetings law. Well, what's a public meeting? What kinds of meetings are covered if you're a local public body? There's a very short definition in the statute. It means any kind of gathering convened to discuss public business. It goes on, in person, by telephone, electronically, or by other means of communication. So we all understand what being in a public meeting is when we're all in the same room in the city council chambers. But what about if you're on a conference call? Well, the statute says that's a public meeting because you're all convened, you're gathered together, and you're interacting with one another over the phone. It's a little trickier when we get to electronic communications, and with the advent of email, of course, and various forms of communicating electronically, the older open meetings law in Colorado is frankly being amended and being stretched to cover electronic gatherings. I will tell you the advice I give my local government clients when they're asking me about communicating by email. I tell them this. I say you can communicate one-on-one in email just as you communicate with one another in the grocery store, just the way you communicate with one another on the telephone prior to a council meeting. That's not a public meeting. But if you're replying to all on an email that's sent to the entire council or to even a quorum of the council, then let's think about it. What you're really doing in engaging in that kind of electronic email exchange is no different fundamentally, is it, than if you were exchanging those views with those council members while you were in a physical public meeting. So that's really the test. Are you interacting with council members as a group or council members one-on-one? And an easy way to think about that is the reply to all function, and make sure you don't have that on. Well, let's talk briefly about what quorum requirements trigger the public open meeting law. And again, the statute's pretty clear. It says all meetings of a quorum or 3 or more members of any local public body. Obviously, a quorum, if you're a 7-member council, is 4. So you would say, well, is 4 the number? Actually, that's not the number. It's 3, even though your quorum in a city council might be 4. The reason for this, I believe, is public policy, that there be the minimum number of people necessary to trigger the requirement for a public meeting. That means you have to be fairly careful. If there's 3 of you, even if quorum is 7 in your jurisdiction, that's still an open meeting. It means that it's open to the public. Now, clearly, if you're going to be taking any action, you need to have noticed that meeting. But if you're merely gathering, the meeting doesn't have to be noticed, but it is open to the press. Let's talk briefly about work sessions. Many communities hold work sessions, and those are fine. In fact, they're very helpful to the decision-making process. But there is a point at which the actions of a work session end up predetermining not only the discussion, but the outcome in the public meeting. If your work sessions are openly noticed as public meetings, then you can certainly conduct them, and most communities do. But in my opinion, it's important to stop short in the work session of actually making the decisions that you're going to later make in a public meeting. It's better, frankly, if work sessions are devoted to items that don't require a decision right away, but are truly work sessions. However, most communities will end up talking about some things that end up on their public meeting agenda in work sessions. Again, that's fine. There's one case in Colorado that's probably the best case to remind us what the limitations on the use of work sessions are, and that's a Bagby versus School District. It's a 1974 Colorado Supreme Court case, and in that case, the members of a school district board would hold regular work sessions, frankly, that were not open to the public. They'd discuss all the matters that were going to be on the public meeting later in that agenda, later in that day. They'd frankly come to agreement on everything. They'd then convene the public meeting, which would take about 5 minutes, and they'd take all the motions and vote on everything. And it was clear to the court that the actual discussion of the public's business wasn't happening in the public meeting. It was happening in the work session. So that's something to avoid. Briefly, let's touch on executive sessions. As the Open Meetings Law requires, all meetings have to be open, don't they? Well, of course, there's exceptions. And my favorite analogy is Swiss cheese. The rule is that meetings are open, so that's the cheese, but there are some holes in that cheese, some exceptions, and one of those is for executive sessions, where you can have a meeting of a public body with a quorum that is not open to the public. And there's a series of topics in the statute, which time here doesn't permit me to go through, but there are a series of topics upon which you can have an executive session. Some of the key ones that will not be surprising to you are legal advice, instructing negotiators, talking about the potential purchase of real property, personnel matters. You can go into executive session, but you need a 2/3 vote of a quorum to convene that session. And it is required by the Open Meetings Law that you recite the topic of the session and the particular statutory site that is the basis for your going into the session before you do so. A final point on executive sessions, and that is who can waive the privilege. It has happened and probably will in the future that there will be a council member or member of the body that feels that they can talk about what happened in the executive session and share that with the press. And there have been some litigated cases on that point. The case law is very clear. Individual members of the body can't waive the executive session privilege. Only the entire body can waive that privilege by voting to waive the privilege. So bear that in mind. As an individual member, you don't have the right to share executive session information with others. Only the entire body has the right to be able to do that. Well, let's now move to our next topic, which is the importance of a strong chair and the role of the chair in conducting a public meeting. I will tell you that I believe this is one of the most important roles that we have as local government officials, is the role of leading the meeting, because you're really not only leading the meeting for the members of the body, you're setting the tone and being the example for the members of the public that are there. And there's nothing more important, I believe, than a chair who runs a good meeting and communicates to the entire populace that's in attendance, both physically and perhaps over watching on television, that this is important public business. It's reasonably formal, and the chair and the other members of the body are treating it with respect. So let's talk about some of the characteristics of a good chair. Well, first, the chair sticks to the agenda and doesn't wander. My best analogy is of an air traffic controller. That's what you are as the chair. You are doing more than simply attending the meeting. You're leading the meeting. As a person is speaking, you're not only listening to that speaker, you're planning on what speaker's next. If there are no other speakers, you're planning to turn to the council members and ask them if they have questions. If council members are speaking and they're about done with the discussion, you're planning on asking them if there's a motion that they want to make. You're looking at your packet to make sure you have the draft motion, if it's available to you in the staff report, in front of you, so that you're ready to lead someone or direct their attention to that motion if it's time for them to make that motion. These are all functions of a good chair. One of the functions of a chair is to also keep the members on time, because it's very easy, of course, for meetings to degenerate into a discussion that just burns up time, and frankly, the body has already very well discussed a matter, and it really is time for action. But unless the chair makes the effort to encourage a motion, sometimes you'll end up discussing it yet again and plowing the same ground. So there's a real art to knowing when is the right time to ask for a motion. It can't be too soon. You have to make sure the body has fully discussed the matter, but you can tell when they have and they're about to begin repeating themselves. And there will be a little pause normally at some point, and you can say, well, gee, I'll entertain a motion on that. Or would you be inclined to make a motion, Council Member X? The draft motion's on page 26 of the staff report. If someone's not accommodating you and not helping you get around to having that motion made, one trick that I've seen good chairs use is waiting for someone to speak passionately on one side or the other of the question, and then the chair will say, is that a motion? Now, of course, the speaker didn't intend it to be a motion, but that speaker also believes in what he or she was saying. And the last thing they're going to do is say, no, I'm not standing behind what I said. That's not a motion. 9 times out of 10, they'll say, well, yes, it is. The chair immediately says, is there a second to that motion? Lo and behold, there's a second. And then you're in action mode right away. And you've moved the body on to the work that they need to engage in. Obviously, you can't play that card at the wrong time, and that's why it's so important for the chair to be thinking about whether the body has had a full discussion on the matter and is ready to act. Now, of course, there are other things that are good examples of the role of the chair. It certainly doesn't take jokes or make unnecessary asides or really encourage others to do so. You know, you're leading by example as the chair, and you should make certain that you stick to the rules that you announce at the beginning of the meeting. And it's proper to have some rules for the conduct of the meeting. Those can be requiring people who wish to speak to sign up, asking people to state their name and address for the record. You can certainly suggest that speakers don't repeat their prior testimony and state that they agree with someone that's already spoken. But let me make a suggestion about that. You can make that suggestion, and people won't follow it, and the speakers will repeat one another. Let me further say that I think that's all right. In fact, I support that. Here's why. The members of the public that attend your public meetings may be only in your city council chamber once all year or once in their life. They believe that what they have to say is unique, and to them it is unique. Frankly, you members of the public body have heard that all before. And you've probably heard it before today, you've heard it before in this meeting, and here's another person saying the same darn thing. That's not the case from the perspective of the person speaking, and you're there to listen to the public. It's important that you do so, and certainly they're repeating what someone else said. It doesn't matter. It's really important to them, and it's really important for you as members of the public body to give respect to that speaker. You've asked them to come, you've asked them to speak. If you've done all that, then you owe them the respect of actually listening to them. So, you know, make your rules and stick to them, but understand that speakers may well repeat themselves. A couple of other things that relate to rules of the hearing. Occasionally I'll get people saying, well, gee, is that relevant? We're going to exclude that because it's irrelevant. I've always applied and suggested my clients apply a liberal rule of relevance in public hearings. Honestly, it is you, the members of the public body, that can sort through what's relevant and what isn't. And the amount of time that you spend trying to exclude irrelevant evidence will be dwarfed by the amount of time it would just take to, or frankly, take a whole lot less time just to listen to that evidence and move on and discount it if you like. Finally, and probably most important, thank all the speakers for appearing. The goal of a public meeting is, in my opinion, to make sure that not only the members of the body, but the public attendees leave the hearing feeling it was fair and that their views were heard and appreciated. And I will tell you it's important to listen to the members of the public when they do speak. I have seen committee hearings. Thankfully, it's happened more at the state legislature than local government. Committee hearings where legislators will be sitting there reading the paper while members of the public are testifying, and I think that's terrible. And it sends not only the wrong message to members of the public, but you're not doing your job as a member of the local public body. Well, enough about that. Let's move to quasi-judicial actions. Now, these are probably one of the most controversial, or at least highly examined actions that a local government will take. They are the ones that more often result in litigation than any other action that you take. And I want to spend a few minutes talking about the specific way in which we can process quasi-judicial actions in public meetings. But first, let me distinguish what quasi-judicial actions are. There are two kinds of actions typically that a local elected body will take: legislative actions and quasi-judicial ones. Legislative actions are things like adopting a new land use code, adopting a comprehensive plan, adopting a leash law for dogs or cats, those kinds of things, adopting a tax ordinance, amending your restrictions on medical marijuana sales, for example. All of those are enacting legislation that is broad-based and affects large areas and multiple parcels of property, multiple persons. The distinction between quasi-judicial actions and legislative actions is that for quasi-judicial actions, these actions relate specifically to typically an individual person, an individual parcel of property, and are applications that someone has filed that will be decided based upon criteria in your code applied to the specific facts of their case. What are some examples of quasi-judicial actions? Rezoning is the best example. You've got an individual parcel of property. The owner wants to rezone it from one zone district to another. Variances, any kind of site plan approval, anything that typically applies just your land use code, for example, to a single parcel of property. By and large, more than 90% of quasi-judicial actions are land use actions, where their application is brought by an individual applicant. Well, when something's quasi-judicial, that adds another layer to your duties and your responsibilities as a member of the public body in the public meeting. Among those duties are due process requirements that need to be granted to the applicant. In a legislative context, things are a little messier. That's what legislation is. But in a quasi-judicial matter, things are a little tighter. And why is that? Well, let's think about the title, quasi-judicial. What's that mean? It's not judicial. You're not wearing robes. You're not acting exclusively as a judge, but you're more as a judge, acting more as a judge than you are as a regular legislator, which means that there are some procedural requirements that apply, and they're here on the screen. There needs to be notice to not only the applicant, but to the members of the public and surrounding property owners that there will be a rezoning hearing. The members that appear, both the applicant and members of the public, have the right to present evidence and cross-examination of witnesses. You need to resolve bias, conflicts of interest, and ex parte contact problems as a part of that hearing. And we'll talk a lot more about conflicts of interest and ex parte contacts in a minute. A record of the hearing has to be prepared, and the decision has to be supported by adequate findings. Let's spend a few minutes talking about that. The way a rezoning hearing will proceed normally is you have the applicant present, and then the staff, or the reverse, doesn't really matter. Then you open the hearing, you hear from the public, you close the hearing, you deliberate, and you make a decision. On legislative matters, it's usually simple enough to have a motion that approves that new land use code or that approves that leash law. For quasi-judicial matters, you'll have a similar motion. It'll say something like, I move to approve the rezoning of the XYZ property from R1 to C2. But it is important, especially to defend your action, that that be supported by findings. Typically, you'll find those in the staff report. And the staff report will tell you why the staff believes the rezoning is proper or should be denied. It's important that your decision be supported by findings. One of the easiest ways to do that in your motion is to say, I move that we approve this rezoning for the reasons set forth in the staff report. That's a short form, poor man's way of getting findings without having to orally yourself recite all those findings. Honestly, there are some boards of adjustment that have members that are very good at creating findings during the hearing and then reciting those, making little notes and then reciting those as the reasons that they're saying yes or reasons that they're saying no to that particular application. I mentioned earlier that we talked about conflicts of interest. Conflicts of interest is important not only for quasi-judicial matters, but for really any action that the local governing body will take. And the rule in Colorado is that you must not have a conflict of interest and remain on the body. The devil, of course, is in the details. How exactly do you define what that is? How do you know that your interest in a matter or your connection with the applicant through your church, through a business association, through blood or marriage, is a conflict of interest requiring you to step down or not? Well, that's what this part of the presentation hopefully will help you address. To begin with, I want to make the point that conflicts of interest aren't true simply because you know someone. It's common, frankly, for you to be accused of a conflict of interest merely because you know someone and therefore you can't serve on the body and can't vote on this matter. Honestly, if that were true, no one would be able to serve on a local government body, especially in a small community. Isn't that true? Because you know most of the people in that community. So it's got to be more than that, and a conflict of interest is not presumed. In fact, there's a presumption against a conflict of interest. That can be overcome by actual evidence of bias or a real conflict. Now let's talk about what that actually can be under Colorado's statute. There's a state statute that was enacted not too long ago in Colorado entitled Standards of Conduct. The most important rule I can tell you about conflicts of interest is this. If you have one, and we'll talk about what they are in a minute, you need to disclose that you have such a conflict. You don't vote on the matter, and you should not influence others on the matter. For me, that typically means leaving the dais at the very minimum and possibly the room. We'll talk about ways you can do that in a minute. The statute goes on to say that you may not accept gifts that would improperly influence you or are given for the sole purpose of rewarding you for an official action. Overall, of course, you have to keep an open mind to avoid prejudgment on a matter. Well, what does the statute say is a conflict of interest that requires you to disclose it, not vote on it, and not influence others? The statute has a number of parts to it, but the best way of summarizing it, in my opinion, is that a conflict that requires you to step down has to carry the potential for some kind of financial gain or loss. As that character in that movie once said, follow the money. That's what we do for conflicts of interest analysis. Is there a potential for your vote on this matter to affect you personally, financially, in a positive or negative way? If that's true, then you have a conflict. As well, you'll notice that the definition at the bottom of this particular screen says personal or private interests. Well, what are those? What's a personal or private interest beyond just a financial interest? That would be a close family relationship, husband, wife, daughter, son, possibly brother-in-law, certainly a business associate, even if it weren't true that you potentially might get money from the approval of the application. The fact that you have such a close business relationship is likely going to be a conflict of interest that would require you to step down. Let's have some examples of what that might be. It's a zoning matter, and you, as the board member, are the applicant or you represent the applicant. That's an easy definition of conflict of interest that you need to step down on and get someone else to present your project. Let's say you own or have an interest in a business which is making the application or which is a consultant to the applicant. That's a lot more common, frankly. If you have a financial dealing with the applicant, if you have a financial business interest in a business which is a competitor of the business making the application. So to the extent the business making the application is approved, then that affects negatively your business. Let's look at all of these. All of them, in some way or another, have a financial connection for you and a financial implication for you. Let's talk about some things that are not conflicts of interest, but you will often be told they are. I disagree. You're related by blood or marriage to the applicant in a less than intimate way. They're not your husband, wife, son, father, mother, but there's no financial connection. You know them. It's a cousin. To the extent that relationship is immediate, it's a problem. But to the extent it is not, and there's no financial connection, I believe that you can remain on the board. You're the next door neighbor of the applicant. You know each other. You're friends. You go to the same church. You play golf together. You like each other. You dislike each other. None of these things amount to a financial connection or a close personal connection that would require you to step down. I mentioned earlier that we talk about ex parte contacts, especially as they relate to quasi-judicial matters. Let's remember again that when you're dealing with a quasi-judicial matter, it is important that all of the evidence that's heard by the local governing body be heard by the body as a whole and be heard by the other parties, not only the applicant, but the opponents of, say, a rezoning application. When you're in court and you're suing someone in court, you do not expect that the judge will have a private meeting with the plaintiff on the other side of the case, for example. That would be an impermissible ex parte contact for the judge to do that. The judge would have to disqualify him or herself. You'd have a mistrial and you'd start all over. Well, those same rules largely apply to quasi-judicial matters that local governing bodies undertake. So if it's a rezoning application, you're really sitting as kind of a judge on the case, and you shouldn't be talking to the applicant or the opponents, the neighborhood that doesn't like the rezoning, outside of the hearing room. It would be the same as if that judge in the earlier case I described was having a private meeting with the plaintiff. You would be incensed if that were the case. And the same thing is true in the rezoning application. It's difficult to explain that distinction generally to members of the public. And this is because they are used to calling you up as their legislator, as their council person, as their county commissioner, and telling you what they think you ought to do on the zoning coordinates or on the land use plan or on that leash law. They don't make a distinction between all those things, which are all legislative, and it's perfectly fine for them to call you up privately, and that rezoning application, which is quasi-judicial, and it's not perfectly fine for them to call you up. This is a long way of saying those are communications between a board member and a member of the applicant or a member of the public that take place outside of the notice public hearing, and they're not permitted for quasi-judicial matters. And let's remember those are typically matters involving individual parcels of property that people have made an application to be approved. The reason it's prohibited, of course, it denies due process to the applicant, and in an extreme case can result in overturning or being a basis to overturn the decision that you make. So let's talk about some ways to avoid these kind of contacts. Typically you'll be called up or approached in the grocery store by the applicant or a supporter or an opponent. And if you do that, if that happens, and you identify the matter that they're talking about is going to be this quasi-judicial matter, it's a pending zoning matter, you have to immediately say, look, as a board member, I can't talk with you about this outside of the hearing room. Urge them to come to the hearing, and then everyone can hear their point of view. Now, frankly, a lot of people won't be satisfied with that. They don't want to have to come to the hearing. That's why they elected you. So you'll need to go to Plan B, which is to say, look, if I listen to you, I'm going to have to step down. I'm not going to be able to vote. And that, I think, appeals to their self-interest. The reason they're talking to you is because they want you to vote one way or another. And if they understand that that conversation might result in them not being able to vote on the matter, then hopefully they'll understand. Door 3 and 4, as far as I'm concerned, is saying, look, it's hard for me to understand or explain, but the city attorney, the county attorney says that I can't listen to you. You got to come to the hearing. I'm really sorry. Door 4 is that you hear your wife calling you from the next aisle over and you have to leave. Any of those things is fine. Just make sure that you limit the conversation as much as you can. Now, it will, of course, happen that you've heard a little bit, or someone will leave you a voicemail, someone will send you an email. What about that? Those are solvable problems. All you really need to do is place those in the record. And the way to do that is that if you get an email or written information, give that to the staff. They'll have that copied and shared with all of the members of the body before the hearing begins. If someone had a very short conversation with you before you were able to really disengage from them, it's very easy at the beginning of the hearing to get the attention of the chair and say, Madam Chair, I was approached by Mr. X in the grocery store who told me that he opposed the application. I told him that he needed to come to the hearing. Doesn't matter if Mr. X later shows up at the hearing or not. What matters is that you've told the rest of the body what transpired. It was fairly short, and you've solved the ex parte problem. However, if you went to lunch with Mr. X and allowed him to lobby you for all of lunch, that's not going to be something that you can adequately disclose on the record and cure that problem. And frankly, you're going to need to be able to, you're going to have to step down in that circumstance. So there's plenty of reasons not to be in that, place yourself in that circumstance. And I've given you, hopefully, the ways that you can avoid that. I want to conclude with giving you one cautionary tale out of the city of Shawnee, Kansas, arising in 2004. And I use this particular case because it has an absolute wealth of violations of all of the rules that we've been talking about, all in one place. And it's unusual that that's the case, but it certainly is. Briefly, the facts were that there was a member of the city's planning commission. He became the 55% owner of a company, which in turn was the contract purchaser of a property. That company filed a development application for the property, and the representatives of the company proceeded to have conversations with every member of the planning commission prior to the public hearing on the application. The application was placed on the consent agenda for the planning commission, and it was placed on that agenda right after a very controversial landfill project application. So in a conversation with a city council member, and let's remember our person was a planning commission member, prior to the hearing, the planning commission member said, that's my strategy. I'm going to put it on at the end of the meeting. They'll be tired. It will sail right through. Who hasn't done that before? Fair enough. At the hearing, the planning commission hearing, and here's where it gets interesting, and I think the violations begin to take place. The planning commission member, despite the fact that he was 55% owner of the applicant that was making the application, did not step down from the commission dais until after the staff recommendation and the opponent testimony. Then he did step down, but he didn't leave the room. Instead, he urged the rest of the commission to vote in favor of the application. He didn't identify himself as a member of the commission in his remarks or disclose his ownership in the applicant. On the transcript, he said he was the general managing member of the applicant. He was the developer. And he didn't vote on the application, but he never left the room during any of the proceedings. Interestingly, a member of the city council observed that planning commission meeting, and the wonderful quote in the case was that the council member was left with the impression that the approval of the proposal was not exactly kosher. Well, that I think probably is an understatement. Now, the city council in that case had a call-up process where commission consent items got called up to the city council, and the same planning commission member testified that prior to the council hearing, he talked to individual council members and the mayor to support the project. Now, your ex parte communication alarm bells ought to be going off now, and I'm sure that they are, because of course those were ex parte communications by the applicant of the decision-making body. Now, let's kind of list for fun here the number of things that were probably done wrong in this case. Well, to begin with, the planning commission member engaged in ex parte contacts with the commission members and the council members before each hearing, and other members of his applicant team conducted ex parte contacts with members of the commission before the hearing. The planning commission member failed to disclose his interest to the chair on the record at the outset of the hearing. He failed to step down and leave the room. Instead, he presented the case on behalf of his own application to the commission. He didn't make any written disclosure of his interest as required by a separate Kansas statute, and he clearly used his position on the commission to advocate for the project. There was other facts in the case that he misused his relationship with the head of the planning department. But more importantly, I think the ex parte contacts he engaged in, and the fact that he went ahead and urged the members in public meetings to vote on the application without just fully disclosing his interest, made for an easy case for the Kansas Supreme Court to remand that for a new hearing at which, said the court, this particular member would not be allowed to participate. What's the takeaway from this? It's at the bottom of the screen. Integrity in public service is important, and someone is likely always watching. I want you to know I appreciate your taking the time to listen to this webinar, and I hope that it's been of use to you. Thank you so much.